Hello everybody, this is Crypto BitLaw back with another video for you today. This one focusing on Terraform Labs and their products Luna and Terra stablecoin and the issues regarding their lawsuit with the SEC, both suing the SEC and being sued by the SEC. But before we jump in, I just want to remind everybody that nothing here is intended as legal or financial advice. So jumping in, I'd like to give a general overview as to what is Terraform Labs. Terraform Labs is a privately held computer software company that was founded in 2018 and is headquartered in Seoul, South Korea. The company's founders are listed as Daniel Shin and Do Kwon, and the company's official legal name is Terraform Labs Pte Ltd. Terra's Crunchbase profile, as we can see right here, states that Terra is a price-stable cryptocurrency designed for mass adoption. It builds financial infrastructure for the next generation of decentralized applications. Terra is backed by Luna, a decentralized asset that derives its value from transaction fees collected on the Terra network. Much like the moon stabilizes the Earth's rotation, Luna is Terra's eternal guardian of. The company's LinkedIn page states that Terraform Labs is powering the innovation of money. Terra is building a decentralized, price-stable cryptocurrency that will gain usage as a means of payment at massive scale through an alliance of large-scale commerce partners across the globe. Terra has raised a total of $58 million in funding over 15 rounds. Their latest funding was raised on January 26th of 2021. Investors include Pantera Capital, Galaxy Digital, Arrington XRP Capital, Coinbase Ventures, and a host of others. Terra held an initial coin offering on February 1st of 2019. This Yahoo Finance article, cited below in the description, does a deeper dive into Terra's host of investors, and it goes on to describe Terra as an application-specific blockchain built on the Cosmos SDK and Tendermint consensus. The Terra protocol deploys a suite of algorithmic fiat-pegged stablecoins underpinning a thriving DeFi ecosystem like Anchor, Chai, and Mirror Protocol. Luna, the native staking and governance asset of Terra, absorbs the short-term volatility of Terra's stablecoins, with Terra's stablecoin demand a function of demand for Terra's DeFi ecosystem, accruing value to Luna via seigniorage. Terra's docs provide a more in-depth description as to how the actual Terra protocol functions. The docs state that the Terra protocol is the leading decentralized and open-source public blockchain protocol for algorithmic stablecoins. Using a combination of open market arbitrage incentives and decentralized oracle voting, the Terra protocol creates stablecoins that consistently track the price of any fiat currency. Users can spend, save, trade, or exchange Terra stablecoins instantly, all on the Terra blockchain. Luna provides its holders with staking rewards and governance power. The Terra ecosystem is a quickly expanding network of decentralized applications, creating a stable demand for Terra and increasing the price of Luna. The Terra protocol consists of two main tokens, Terra and Luna. Terra is a stablecoin that tracks the price of fiat currencies. Users mint new Terra by burning Luna. The stablecoins are named for their fiat counterpoints. For example, the stablecoin that tracks the denomination of the US dollar is named Terra USD, or UST. There's also Luna, which is the Terra protocol's native staking token that absorbs the price volatility of Terra. Luna is used for governance and mining. Users stake Luna to validators who record and verify transactions on the blockchain in exchange for rewards from transaction fees. The more Terra is used, the more Luna is worth. So that was just a basic general overview of how the Terra protocol functions. You can learn more about it in these docs listed below. So from here we'll move on to Do Kwon, who's the founder of Terraform Labs, and he's presently at the heart of a lot of Terra's recent legal issues. So I'd like to preface this section by stating that Do Kwon is brilliant. Every time I've heard him speak, I've been blown away. Do Kwon was also recently named one of CoinDesk's most influential figures of 2021. Do Kwon is the 29-year-old founder of Terraform Labs. Kwon is a Korean national who spent years in Canada and graduated with a bachelor's degree in computer science from Stanford University in California. After about 5 years at Stanford, he took a software engineering job at Microsoft. Thereafter, he left Microsoft to pursue private projects. In a May 23, 2021 tweet, Do Kwon stated, "I hold the majority of the team's Luna holdings, and I bought 50 million Luna in 2020, and also bought more Luna in 2020. Aside from Do Kwon's open admission that he holds the majority of Terraform Labs' Luna holdings, It's also worthwhile to consider this tweet that he posted in response to a Cointelegraph tweet regarding banking committee members seeking notices from several popular crypto firms regarding information about their stablecoins. Kwon tweeted, "Didn't get one, feel left out, UST." So it's almost like he's kind of poking the bear here. So that serves as a good transition point into the legal issues surrounding Terraform Labs, as it applies in particular to Kwon. Back to this CoinDesk article about how he was named one of the most influential crypto figures of 2021. It states that Kwon, the 29-year-old founder of Terraform Labs, was running late, being subpoenaed by a hired hand of the U.S. Securities and Exchange Commission, SEC, didn't help. Not that he knew it was coming, due to appear on stage at any minute at Mainnet 2021, a major cryptocurrency conference in New York City, a process server slipped him a manila folder which he accepted unthinkingly, he said. He threw it in his backpack, got on stage, and forgot about it. He still hasn't read the document, now in his lawyer's possession. Kwon told CoinDesk in an interview in November, quote, "I didn't read the press release, but it seemed like they were talking about MIR, or something like that," he said, with practiced nonchalance. He's referring to the Mirror Protocol token, MIR, an asset he helped design that's used on the platform of the same name. This article continues, "The Mirror Protocol, indeed the project in the SEC site, makes it easy to create and trade synthetic versions of other assets, like highly regulated U.S. stocks, without restriction. The SEC is investigating whether Mirror falls afoul of the law just for that reason, enabling the sale of unregistered securities. It's a serious offense, but hardly rare in crypto. Quote, when I'm trying to launch things, my primary area of interest isn't what the state would appreciate," Kwon said. Further down, this article notes that Kwon states that we think a decentralized stablecoin should replace Tether, referring to the current market leader, the Tether stablecoin. This article also states that the SEC, under new management, is taking a more aggressive stance against the crypto industry this year. Chairman Gary Gensler has said that the majority of crypto tokens are likely securities and therefore the agency's responsibility. He also invited founders of crypto firms to discuss their platforms and ambitions, a process that Terra has engaged in. As part of its subpoena, the financial watchdog demands that Kwon and Terraform turn over documents and provide testimony related to a platform that, by design, doesn't collect customer information or set limits around who can access it. In an hours-long in-person meeting before any paperwork was filed, federal agents allegedly asked for data about who owns Mirror tokens and who uses Mirror. Quote, "We don't have that information," Kwon said. He added that the agency was confusing Mirror with a traditional company rather than a free software project. Quote, "I don't think people believe us," he said. The agency said Kwon has deliberately stymied their inquiry. Quote, "We have limited visibility into, what exactly they're thinking here," Kwon said. This isn't just dismissive swagger. Last month, he and Terraform sued the SEC for, quote, "failure to follow its own rules," their lawsuit read. When serving Kwon at the highly trafficked crypto conference held at a Times Square hotel, although Terra's subpoena is mostly focused on procedural issues, never calling into question the long arm of U.S. law, just how clumsy it can be, Kwon seems prepared to make a larger statement. Quote, "If we really are fighting for a revolution, I think for people at the vanguard, it's incumbent on us to make sure that we speak out, make sure that the views of the industry are heard," Kwon said. The experience working with and now resisting the SEC has been edifying, even if Kwon claims not to have read their paperwork, if only because it has made him realize the gravity behind Terra. So there's a lot to digest there. So I guess just basically in sum, the SEC served a subpoena on Kwon as he was about to go on stage at a crypto conference in New York. Kwon had tweeted out in response to a CoinDesk article or Cointelegraph article about how the SEC or Senate committee was serving subpoenas on different companies regarding information for stablecoins. And Kwon kind of poked back at them, saying he felt left out that he didn't get one. After he got served the subpoena, he then in turn sued the SEC, alleging that the SEC failed to abide by its own rules and was engaging in regulatory overreach. So let's do a deeper dive into these different issues and then kind of parse them out and see what we can figure out. So to keep all the timing of these issues in order, I provided a timeline over here that provides an overview of when these issues occurred. And it starts out on May 23rd of 2021 with the Kwon tweet where he states that he holds the majority of Terraform's LUNA. Following that, on September 20th, Kwon was served with the subpoena from the SEC. After that, on November 12th, the SEC filed an action against Do Kwon seeking an order to comply with the subpoena. Soon thereafter, on November 22nd, Do Kwon sued the SEC, and then following that, there was the Do Kwon tweet in response to, I think, that Cointelegraph or Coindesk article about how the Senate sent out requests for information from stablecoin providers, and Do Kwon responded that he didn't get one, and so that he felt left out. Here we have a press release from the SEC that states that the SEC files a subpoena enforcement action against Terraform Labs and its CEO. This is dated November 12th of 2021, and the caption of the action is Securities and Exchange Commission versus Terraform Labs Pte Ltd and Do Kwon, and then the case number, and it was filed in the Southern District of New York on November 12th of 2021. As you can see over here, if we take a look at the docket for the SEC's case against Terraform Labs, we can see a few things. It begins with the petition to enforce administrative subpoena that the SEC filed against Do Kwon and Terraform Labs, and it eventually progresses, and then we can decipher that what had happened was the defendants here, Do Kwon and Terraform Labs, eventually filed a motion to consolidate cases. So the case that Do Kwon and Terraform has, where they sued the SEC, they are seeking to consolidate their case where they're suing the SEC with this particular case where the SEC is suing them. And we can get a little bit more information. There's a response that was filed here on behalf of the SEC where the SEC pretty much agrees that the cases are related. However, they state, quote, the extent that the respondents also sought consolidation of the actions under Rule 42 of the Federal Rules of Civil Procedure, the court should deny that request because the subpoena enforcement action and the civil action are governed by different rules setting forth different procedures and timelines and are therefore inappropriate for consolidation. And ultimately it concludes down here. It says, accordingly, the SEC respectfully requests that the court resolve the SEC's application for an order to show cause and an order requiring compliance with the SEC investigative subpoenas and denied the respondent's motion to consolidate. So the SEC is asking the court to deny the respondent, Do Kwon and Terraform Labs, motion to consolidate and just proceed with the SEC's request for an order to comply with the investigative subpoenas. As we can see down here, the most recent entry on the docket, entered on December 3rd of 2021, is setting the matter for a status conference. There was another entry in the docket on December 3rd of 2021 stating an order on the motion to consolidate cases, but I don't have any information as to what that order actually was. I pulled up another docket monitor over here where it lists those same dates and states that there was a telephonic status conference held on December 3rd, and it ordered a response to the pending motions by the respondents, that would be Terraform Labs and Do Kwon, and that response is due by December 17th. What's also interesting here is there is a copy of the subpoena that was served on Do Kwon right here as an attachment in this docket entry. I'll do a deeper dive into that in a little bit. Here's a copy of the lawsuit filed on behalf of Terraform Labs and Do Kwon against the SEC. As we can see right here under the summary of actions, it states that this is a lawsuit under the Due Process Clause of the 14th Amendment, the Securities and Exchange Act of 1934, 15 U.S.C., Section 78A, et sequitur, the Administrative Procedures Act, and then it lists the law, and the SEC's rule of practice, the SEC's rules, quote unquote, challenging two subpoenas improperly issued and served by the SEC and the SEC's failure to keep confidential an investigation into the Mirror Protocol, all in violation of the Due Process Clause and the SEC's rules and the APA. So in this lawsuit, Do Kwon and Terraform are alleging 3 counts, count 1 being arbitrary and capricious agency action in disregarding and violating the APA and the SEC's rules regarding service of subpoenas. And count 2 is arbitrary and capricious agency action in disregarding and violating the SEC's rules regarding the confidentiality of formal orders of investigation. And count 3 is violation of the Due Process Clause of the 14th Amendment. So here, under the prayer for relief, we could see what the plaintiffs, Do Kwon and Terraform, are asking the court for. They want A, declaring that the subpoenas were issued and served in violation of the APA and the SEC's rules of practice, and that they're null, void, and with no force or effect, and in particular were not effective in securing jurisdiction over Terraform Labs or Mr. Kwon. They also want to declare that the SEC acted arbitrarily and capriciously within the meaning of United States law in issuing and serving the subpoenas. They want the subpoenas quashed. They want a declaration that the SEC acted arbitrarily and capriciously within the meaning of United States law in failing to maintain the confidentiality of the formal order. They also want the court to issue all orders necessary and appropriate to adjourn the compliance dates of the subpoenas in their entirety and to maintain the status quo pending the conclusion of this case. They want to award the plaintiffs their reasonable costs, including attorney's fees incurred in bringing the action. And then they have the catch-all clause here, awarding plaintiffs such other and further relief as this court deems just and appropriate. Here's a copy of the docket for the Terraform Labs case against the SEC. As we can see here, there's nothing I could find about a consolidation with the other case where the SEC sued Terraform Labs. And the most recent docket entry is on November 23rd, and it's an order on a motion to appear pro hoc vice, one of the attorneys. So as I stated earlier, in the docket of the case where the SEC sued Terraform Labs, you can see here entry number 4. It is a notice of declaration by Roger J. Landsman, who's an attorney on behalf of the SEC, together with some attachments. And here is a copy of the declaration in support of the U.S. Securities and Exchange Commission's application for an order to show cause and an order requiring compliance with the subpoenas. Now, this is an interesting document because it just kind of goes over this attorney's involvement in the investigation into Terraform Labs and gives some information regarding that, but it also has as an exhibit a copy of the subpoena, which we can see over here. It's listed as Exhibit 8. Now, this subpoena is pretty intense. This is a 28-page document where it just goes over the type of information requested on behalf of the SEC and how that information should be produced. I mean, they've got a couple pages here of definitions. They do a definition of mirror assets, Terra, what a document means, what electronically stored information is. It just goes on and on and on. And then instructions, a few pages of instructions on how to comply with it, and then the actual documents that they want. We can hear it starts, wow, all the way up here. I'll give you some examples. Documents sufficient to identify all investors, token holders, owners, or beneficial interest holders in the MIR tokens, including but not limited to the date of investment or acquisition, amount of investment or consideration by US dollar equivalent, and digital asset amount if applicable. All presentation by Terra to investors, potential investors, token holders, or potential token holders, all communications with investors, all agreements between Terra and third parties regarding the sale or transfer of mirror assets, smart contracts, automated market makers, coding journals, code change logs, oracles, documents specific or sufficient to show the mechanism by which rewards would be allocated. I mean, this is a lot. There's also a section down here further on in the document of the subpoena where it sets forth data delivery standards, and these are pretty stringent standards. We can scroll down and get to the point where they set forth a standard for how they want the metadata to be extracted and provided in a .dat file using the below listed field definition and formatting described. I mean, to produce all this and how they want it, you would need a team of analysts and programmers. There's a lot involved with this. And then to round it all out, you have a certification that they want to be signed below. Let's see, it's right down here. It's a declaration of, bracketed insert name, certifying records of regularly conducted business activity, where they want an employer authorized to make the declaration to certify that the records are true and accurate, and pretty much you're certifying to this under the penalty of perjury. So it's one of those things where, I mean, if you leave something out and they can catch you in a lie or catch that you didn't actually provide them everything that you had access to, you can get into even bigger trouble. Now, you can go check out the details of all the different parts of the subpoena yourself. The link to it's going to be listed in the description below. But I'll just say this, if I were to get one of these, or if you get one of these, this would definitely ruin your weekend, at the very least. You do not want to be dealing with something like this. So in terms of where we stand now, it seems that Kwon and Terraform Labs are trying to go on offense for a bit, as is evident by their suit against the SEC. And it seems like ultimately what they're doing is buying some time with the enforcement of the subpoena that gives them more time to strategize and then delay the actual enforcement of the subpoena. The subpoena is kind of like this giant Pandora's box, and once the SEC actually gets enforcement action over that, it could open up all sorts of issues that could create a snowball effect of different headaches and discovery. So it appears that both sides are engaging in litigation strategy, whereby the SEC is essentially embarking on a fishing expedition, seeing what they can find, and then potentially using things that they find in order to dig further and deeper. And on the other side, Kwon and Terraform Labs are trying to delay the enforcement of the subpoena through strategic litigation, attempting to regroup and strategize while at the same time engaging in a counteroffensive and potentially even getting the subpoena quashed. So that's where we stand now. I hope you guys really enjoyed this content. We enjoyed making it. Please look out for more videos in the future regarding different issues and topics that stand at the intersection of law and blockchain and crypto assets. And we'll see you guys in the next video. Don't forget to like and subscribe. Thanks.